Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus Apollo Tyres Limited. This case has been reported in 449 ITR at page number 398. The matter has been decided by Kerala High Court and the date of the judgment is 23rd September 2021. This case relates to the assessment year 2009-10 and the matter goes in favor of the assessee. This case is very important in respect that this case throws the light that what is the role of the procedures in passing the assessment orders or the role of procedures in the law field. In this case, the matter of transfer pricing was involved. The assessing officer referred the matter to the transfer pricing officer. Transfer pricing officer proposed some upward additions and assessing officer issued draft assessment order to the assessee. The assessee raised the objections to the draft assessment order and then the learned assessing officer passed the assessment order. When this assessment order was the subject matter of the appeal, this matter was remanded back by the ITAT to the assessing officer for reconsideration. When this matter was remanded back to the assessing officer made some additions on behalf of the transfer pricing matters, and this time he issued the assessment order without issuing the draft assessment order to the assessee. And when this matter came before a long litigation before the Kerala High Court, the main apprehension of the assessee was that the due procedure of the law has not been followed. The assessing officer has passed the assessment order when the matter was remanded back to him without issuing the draft assessment order to the assessee under section 144C. So the moot question in this case was that whether in case of remand back matter, the assessing officer has to issue the draft assessment order or not. Basically, what is the purpose of the draft assessment order? The draft assessment order is like a show cause notice to the assessee, which gives the assessee an opportunity to put his stance for the additions which have been proposed through the draft assessment order. Remanding back does not mean that the principle of natural justice will not be followed for the second time. Basically, the main purpose of remanding back is that whatever have been left in the first round of litigation, that can be completed in the second round of litigation. So, if in first round of litigation something was left and after remanding back the matter, the department does not issue the draft assessment order, that it means that the assessee has not been given the proper opportunity to keep his point in the matter of the assessment. And the point of the department was that there is no requirement in the law that the draft assessment order should be passed in the case of remand back also. So the Kerala High Court in this case decided in favor of the assessee and held that it was the prerequisite before issuing the final assessment order, whether it is in case of original assessment or it is in the case of second round of litigation. It was the duty of the assessing officer to issue the draft assessment order to the assessee so that he can put his objections before him and only then the final assessment order can be passed. Friends, this case is very important. Sometimes it happens that the assessee may be weak on the merits, but if we can search these type of issues into the assessment where the due procedure has not been followed, in that case sometimes the matters are remanded back by the courts and sometimes the matters are quashed by the court. So in this case the court quashed the matter and the assessee gets the relief because the draft assessment order was not issued to the assessee in case of remand back matter. Once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Apollo Tyres Limited, and this case has been reported in 449 ITR at page number 398, and the matter has been decided by Kerala High Court, and the date of the judgment is 23rd September 2021. Thank you, friends.